Good afternoon. I usually try to remember to tell everybody that the arguments are live streamed, but with the storms we had last night, we've had problems. So the arguments today may or may not be live streamed. They were working on it. Hopefully we're okay. We're back up, so they say. Call the first case, please.
Siskin Hospital for Physicians Rehabilitation, Inc. versus Dr. James Peter.
We'll hear from the appellant.
Rebecca Little here on behalf of the appellant.
Pull the microphone over in front of you, please, or move over there so we can hear you.
I first have a preliminary question. May I reserve some of the 15
Yes.
minutes for rebuttal?
Yes. How much would you like to reserve?
Probably 5 minutes.
5
maybe.
minutes will be fine.
To begin, this case is about a non-qualified pension plan to which Siskin Hospital invited Dr. Little, the appellant, to participate in 1990 when he was acting as Siskin's medical director. Little made 5 contributions over a 6-year period from 1990 to 1996, totaling $37,500. At a reasonable rate of interest, that would be close to, worth close to $600,000 today. The funds in this case are made up 100% of the deferred compensation of the participant.
Close to how much?
Close to $600,000 at a 9% rate of interest compounded annually. The funds in this case are made up 100% of the deferred compensation of the participant. None of the money came from Siskin. The funds were properly commingled with Siskin's investment portfolio and were collecting interest alongside Siskin's other investments. So if Siskin pays Little's benefits, there's no net cost for Siskin. Siskin doesn't deny that it took Little's money under the auspices of placing the funds into the plan or that it's still in possession of Little's pension funds. The question for appeal is whether the trial court erred or abused its discretion in finding that the statute of limitations passed on Little's claims for his pension benefits. It's important that this case involves a special kind of pension plan, one that doesn't require government oversight. It's a non-qualified top hat pension plan administered pursuant to Internal Revenue Code Section 457. 457 plans can only be administered by nonprofits and governmental entities, and funds can only be transferred to another eligible plan administered by a nonprofit or government agency. 457 plans specifically allow independent contractor participation, which this participant was. Importantly, all amounts of compensation deferred under the plan, all property and rights purchased with such amounts, and all income attributable to such amounts must remain solely the property of the employer. They're subject to the employer's general creditors if they were to go bankrupt, but until they're dispersed to the participant, they belong to the employer. So Siskin was in proper possession of Little's funds and had all rights to the funds until Siskin made those funds available to Little. According to IRC 457, mandatory disbursement age is 70 and a half. There are 50% penalties for dispersal after that. Siskin Hospital and Dr. Little are the 2 parties to the contract. Valak was the firm responsible for administering Siskin's qualified retirement plans. They weren't involved in establishing or administering this plan. Siskin's counsel in 2002 also said they weren't involved with establishing or administering the plan. Neither of those third parties even learned about the agreement until 2002, 12 years after it was made. We have a series of audit letters that were prepared by Siskin's Vice President of Finance as part of an annual independent audit that they performed. The 1996 audit letter states, Siskin Hospital is holding $37,500 in Section 457 non-qualified retirement plan contributions for Dr. Little. The trial court found the authenticity of the audit statements is not in dispute. In 2019, counsel for Siskin confirmed that Siskin Hospital was still the party holding and properly investing the funds. Siskin has placed a lot of import on the fact that Siskin hasn't produced a written plan document. First, there were no regulations concerning 457 written plan documents until 2001. Second, whether a written plan existed and was lost or destroyed or was never prepared is beside the point. All parties agree, and both courts that have heard this agreed, that Siskin accepted contributions of Little's deferred compensation in 5 tax years under the auspices of administering a pension plan with the funds. More importantly, all of Siskin's documentation shows that Siskin was administering the plan by investing the contributions according to the 1990 agreement as late as 2019. Surprisingly, Siskin's statute of limitations defense is premised on Siskin's new position that it committed fraud and theft to obtain and retain Little's money, and that Little should have known about Siskin's fraud and theft and litigated Siskin earlier. The problem with Siskin's argument is that every record and correspondence from Siskin, the other party to the contract, from 1990 to 2019, confirms that Siskin was investing Little's contributions as it should, in keeping with its contractual responsibilities.
Counsel, let me kind of focus you before time goes. What did the trial court, when and why did the trial court find the statute started to run, statute of limitations started to run?
The trial court found that Little's attorney made an inquiry in 2002 and sent the 1996 audit letter intending to potentially roll the funds over into some other approved retirement account. His attorney at the time didn't know it had to be administered by a nonprofit or governmental agency. Little was not employed by either of those at the time. In response to the inquiry, counsel for Siskin did send a letter to the CEO of Siskin saying, you probably want to look into this. Here's this audit statement. Siskin didn't, it's unknown to Little whether Siskin's CEO looked into the issue. Siskin didn't respond at all. So based on that inquiry and that silence from Siskin, the court found that silence in this context would create enough of an indicator that he should have done something. We would argue that silence when there's a fiduciary duty to disclose information would constitute fraudulent concealment and toll the statute of limitations rather than trigger it. There was a second inquiry about rolling the funds over in 2013. In response, there was a new CEO installed in 2014. She confirmed, there are letters showing that she confirmed that Siskin was investing the funds. The funds were still pooled in with Siskin's investments at that time, and she indicated a willingness to pay. She didn't, however, provide any solution as to how to roll the funds over or how they would be treated for tax purposes. So he chose to leave his funds with Siskin Hospital at that time in their investment portfolio.
Wasn't there a letter also to the senator?
Yes, Your Honor. There was a letter in 2003 to Senator Frist. It was about breach of contract and credentialing issues related to a separate litigation that was initiated in 2001. There was an addendum to the letter wherein Little expressed his incredulousness that about the idea that the statute of limitations may have passed on his pension claims, which everybody agrees it wouldn't have by 2003 because there had been no denial, no request for disbursement that was denied.
Wasn't this sufficient information to place Dr. Little on notice that there was something amiss here?
Well, there was no notice at all from Siskin Hospital. There was a suggestion by a third party who had no knowledge about the plan that it hadn't been created because he was not involved in creating the plan. We've had confirmation since then in 2014 and 2019 that there was a plan. It was being administered. Siskin did have the funds. They were tracking Little's funds, and they did intend to disperse the funds. So whatever was said in 2002 was in error and has been confirmed to be an error by Siskin since then.
Well, but he thought he thought he was being wronged.
No, he thought his money was there. He just thought the suggestion that the statute of limitations would have passed on a pension plan to be spurious, to be ridiculous. You know, he wasn't even close to disbursement age. Everything he had from Siskin up to that point, and everything he's gotten since then, confirmed that Siskin was administering the plan. Again, as late as 2019, Siskin's counsel, after looking at the documentation file, said, yeah, we've been investing these funds the whole time. We intend to disperse them. They've been pooled with Siskin's investments. So that suggestion by a third party who wasn't a party to the contract and wasn't involved and had no awareness of the plan wouldn't have triggered the statute of limitations.
Why?
Because it wasn't a party to the contract. It was somebody who was totally ignorant, who basically wanted to wash their hands of it, saying, oh, I don't know about this plan. I wasn't involved in this. I didn't, you know, it's not my error, essentially, is what Ken Span from Valak was conveying.
So what is your position? Your client never received even inquiry knowledge that something was amiss?
He received nothing from Siskin but confirmation that Siskin was investing the funds and that Siskin did intend to disperse the benefits in 2014 and again in 2019. He received nothing from Siskin in 2002. He sent the audit statement that stated the amount of money Siskin was holding in the retirement plan. He got no response.
Okay.
And it looks like I have used up all but a few seconds of my time, so I will close here. Thank you very much.
Thank you. You have your time for rebuttal. We'll hear from the appellee.
Good afternoon. May it please the court, Jonathan Rose from DLA Piper in D.C. With me is Joe White from Spears Redmond in Chattanooga. Appellate asserts that the trial court committed a litany of errors by concluding the record evidence established that the statute of limitations had run over 15 years ago. Appellant claims that there's no evidence supporting the trial court's decision. Appellant claims that there was, quote, never any notice whatsoever or even intimating an intent to deny Dr. Little benefits. It's page 7 of the appellate's brief. Significantly, in making these assertions that the trial court erred in its ruling, appellant totally ignores the evidence, which Your Honors have already raised, that he had actual notice, not just inquiry notice, of the dispute, whether or not he had any rights to benefits under a 457 plan. Significantly, Dr. Little was
Counsel, pull the microphone.
Oh, I'm sorry, Your Honor.
Thank you.
Significantly, Dr. Little's was an independent contractor to appellee, and he was properly terminated with 180 days notice in 2000. Dr. Little sued Siskin based on that termination. Was actually in litigation for 4 years, from 2000 to 2004, with Siskin over this contract dispute. In that suit, Siskin asserted counterclaims for, among other things, of over 50,000 of insurance checks that Dr. Little converted that were sent to him by insurers for reimbursement for services after his termination. Appellant claims, and the record evidence established, that claims that he was covered in a Section 457 plan for employees, for special employees of Siskin, when he wasn't even an employee, and the record evidence is there was never any plan established until 2002, 2 years after his contract was terminated.
Well, did Siskin accept his contributions?
Your Honor, because it is so far long ago, which is part of what we're going to get to in terms of discussion of the statute of limitations, there really wasn't evidence. What they were able to detect going back was that it appeared as though there was 3 years of contributions. They weren't able to confirm 5, but for purposes of the letter that went out, we're not contesting that there was an amount received of $37,500.
Yeah.
I will explain how that bakes into this mess and his notice, though. Dr. Little hired a firm in 2002, Chambliss Bonner, to seek the money he believed he was entitled to under this 457 plan that wasn't even established when he worked there. This is 2 years into the litigation that was pending in the Chancery Court of Hamilton County against Siskin at that time. His lawyer sent a letter demanding that money. He was contacted. It clearly stated that he was informed, counsel was informed, that no plan existed until, at that time, and that Siskin did not have any, did not owe him anything for any benefits. Dr. Little testified that he was informed in 2002 that the plan didn't exist. Dr. Little acknowledged that he was aware he could have had his lawyer amend the complaint that was then pending to add these claims. He chose not to. Dr. Little admitted that he had been advised by Chambliss Bonner that they believed that the statute of limitations had run in 2002, which would make sense since the last contribution was actually in 1995 with the 6-year statute. This is not an ERISA plan. There is no ERISA plan. It's part of the background. This case was litigated in the Eastern District. I'm sorry?
I mean, what was the proof showing that he thought there was a plan?
I beg your pardon, Your Honor?
What was the proof the trial court had in front of it showing that he thought there was a plan?
That Dr. Little thought there was a
Yes.
plan? There was none. He never presented any document suggesting he'd ever been invited. There was no plan document.
What did he say he made the contributions for?
He said that he made them, he said he wrote checks and he handed them to someone who was in finance. It's important to understand, Your Honor, that this was a new hospital and he was the independent contractor who was supplying all the doctors and nurse techs. He was in the executive offices. He wasn't an employee, but
I understand
Yeah,
what you're saying about
so
the plan.
he was handing checks off to somebody.
I'm just curious why it sounds like you're trying to stick him with the fact that the plan wasn't established until after he was gone.
That's right.
But he was never the one who was supposed to establish the plan.
No.
Your client, if your client told him that they had such a plan and he could make a contribution to it, and they accepted the contributions, why is it his fault that the plan wasn't established by your client?
With all due respect, the premise of your question is there was never any evidence he was ever invited to a plan. He wrote checks. We don't know. He says he handed them off, and they were, but there was never any plan. There was never any evidence.
We understand clearly that the plan was not in existence until after he was gone.
But more than that, he never had any evidence, never submitted any evidence he was ever even invited. He wrote these checks and handed them to someone. There was never any plan. You can't...
I understand again. I'm clear that there was no plan.
Okay.
But it wasn't his obligation to establish a plan. For some reason, he wrote checks to your client.
Yes, Your Honor.
And for some reason, your client accepted those checks.
That is correct, and there was some confusion about that, and if you allow me, I will explain that. In this litigation that Dr. Little filed, it was going to be dismissed for failure to prosecute. In 2004, there was a communication between Dr. Little's lawyer and Siskin Hospital's counsel where there was a conversation followed up with about a 20-page letter explaining that we're going to go forward on our counterclaims unless we, agree to some settlement. There was a walk-away settlement. They just voluntarily dismissed the claim. Again, in the counterclaims, among other things, just in pure hard dollars, Dr. Little had converted over $50,000 in about 8 different checks. This is part of the record. And so, it was, that was a walk-away settlement. The parties were just done, and that was the decision. The references to suggestions that Siskin Hospital ever acknowledged any entitlement to Dr. Little of any amounts are only in letters offer of compromise. Dr. Little did nothing, despite the fact his sworn admission was that he knew and had been advised that the statute of limitations had run in 2002. He had a then pending case. He failed to amend to include it. If he thought he had a legitimate claim, he would have. In 2003, he wrote the letter to Senator Frist that you asked about, and in that letter, he acknowledged he'd been advised that the statute of limitations had run. He'd been advised there was no plan. The trial court clearly, in our with all due respect, did not err by recognizing and taking credence of his sworn admissions and his own admissions against interest in these two letters. Dr. Little, after this, there was the walkaway settlement in 2013. He hired another lawyer to make a demand, and that lawyer also similarly did not file any complaint. And, you know, it sort of makes sense if he'd been advised that the statute of limitations is run, he wouldn't want to waste the money. But the reference to 2019, the reference to any letter, the check that was sent was simply a new CEO just trying to end a dispute. And Dr. Little had it sent back. He refused to accept it. It was clear he knew there was a dispute. There were only offers of compromise, frankly, that, you know, questionable whether or not they should have even been in evidence. But the bottom line is there was never any evidence that he was invited to participate in a plan or that there was any promise that there would be a plan. There was some confusion after his termination, which was resolved as a walkaway settlement in 2004. So, with respect to the statute of limitations, Your Honor, I mean, the law is very clear. I mean, if in fact someone can step out after 21 years and assert a claim that they were aware of, had run, they were on more than inquiry notice, the record evidence is abundantly clear that he had notice. Even where this court has ruled, even where there is an admission of liability from an insurer and an insurer does not step forward to take that amount before the statute of limitations run, this court has ruled repeatedly that the statute of limitations is run. The case law is statute of limitations do not discriminate between legitimate and illegitimate claims. We submit this was an illegitimate one, but the bottom line is the record evidence is really clear from his own sworn testimony in the record with respect to his own writings, which are admissions against interest, that he clearly had knowledge. Your Honors, we respectfully, are there any questions about the record? Or?
I hear no other questions.
Okay. With that, Your Honor, we rest on our papers.
Okay, thank you. Hear from the appellant in rebuttal. You know, your opposing counsel makes a good point. That's kind of what the statute of limitations, if a statute of limitation runs, it doesn't matter if it was a valid claim or not.
Yes, Your Honor. This case started with a litany of deliberate misrepresentations by Siskin and has proceeded to this court with significant misrepresentations as well. Siskin never informed Little he wasn't eligible to participate in the plan, that no plan existed, or that Siskin wasn't holding his funds pursuant to its agreement to administer the plan. And Siskin certainly never informed Little it was going to keep his money. Siskin says there's no evidence of his participation in the plan, but we have audit statements every year. We have for 4 of the 5 years that he made contributions, including the final one. These were prepared by Siskin's Vice President of Finance. They say unequivocally, we are holding your money in Section 457 retirement money. So there's the only financial records related to this plan from Siskin unequivocally state we're holding your money in this plan. Siskin attempted to distract from the issue with this insurance payment claim. Insurance payments were often sent to the wrong entity. Siskin Rehabilitation Group was the name of the practice that Little ran. Siskin Hospital was the name of the hospital. Little wouldn't even be the right person to sue if an insurance payment was made to the wrong party. You simply contacted the insurance company and they corrected the mistake. Siskin hasn't provided any evidence that Little stole any insurance payments, and at this point, I think we're getting close to libel here from them continuing to make this claim that he committed some sort of crime. There was no walkaway settlement. Sorry.
One of my major concerns here is at what point did Little obtain any notice that he had been wronged, and from that point, how long was it before he attempted to pursue his rights?
He received no notice whatsoever from Siskin. He made an inquiry in 2002 that Siskin did not respond to. And that's silence.
Back then, if he made the inquiry in 2002, from what point did he actually file suit?
He filed suit in 2019 when Siskin finally said, we're going to keep him, well, in 2020, when he received Siskin's complaint for declaratory judgment, asking the Chancery Court not to allow him to bring any claims. And that complaint actually falsely states that the pension issue had already been litigated and dismissed by that court when it hadn't. So he received confirmation from Siskin in 2014 that Siskin was still investing his funds and intended to disperse the benefits. And then again in 2019, Siskin actually said, your assertions regarding fraud and theft are unfounded. Siskin Hospital remains ready and willing to return the $37,500 principal amount in retirement contributions plus actual interest earned. So as late as 2019, Little received confirmation from Siskin that Siskin didn't defraud him, that Siskin at least acknowledged the agreement to administer the plan, whether there was a written plan or not. And again, all the financial documentation from Siskin, he had real-time audits in 5 years. Either an independent auditing agency was in on some sort of scheme to defraud him, or Siskin was, for all practical purposes, investing the money, as was confirmed in 2019, and administering the plan, whether or not that was pursuant to a written document or not. They were doing exactly what they should do. They were in rightful possession of the money, which is the way 457 plans work, and they were investing and tracking the money.
If the statute started in 2002, which is when the trial court found it started, is that correct?
Correct, based on Siskin's silence.
If the statute started in 2002, what impact, if any, does these later letters in 2014, 26, whenever they are, how does that impact
We would argue
whether or not statute of limitations had run?
Yes, Your Honor. We would argue it would be told by the later assurances. First, Siskin's silence in 2002, we think would constitute fraudulent concealment, according to the case law, because there was a fiduciary duty, there was a duty to disclose if Siskin intended to keep his money at that point. Again, Little attached the 1996 audit statement that clearly says we're holding your money in a retirement account. We also have multiple assurances that Siskin was properly investing the money, which would make application of equitable estoppel proper. And then we have multiple acknowledgments of the debt and promises to pay it as late as 2019, which would also invoke the doctrine of revival. The trial court didn't address any of the tolling doctrines, though in its opinion it did say that it had to address the third element of the statute of limitations defense, and that it needed to be considered alongside accrual because they're interrelated, as the case law identifies. That's all. Thank you.
We appreciate counsel's arguments, both of you, and your briefs on this matter.